Okay, I believe we're up and running. And I'm getting through all the civil rights stuff. So that'll be the last thing I don't think I've recorded. So let's hit this sucker here. And here we go. All right. So you're starting with kind of the early history of the civil rights movement. And so there's two types of segregation we're going to look at, but first we're looking one more time at the difference between civil liberties and civil rights. So civil liberties is freedom from. You need the government to leave you alone. Your freedom of speech, your freedom of religion, your right to bear arms, all that stuff in the Bill of Rights. Civil rights is the freedom to enjoy freedom to. So it all comes down to the preposition. Freedom to enjoy the blessings of liberty. You need the government on your side to help you with your civil rights. There are in turn two types of segregation. De jure segregation is segregation by law. The Civil Rights Act and the Voting Rights Act that we're going to look at, that we have looked at, overcame de jure segregation. Look at the word jury there. I mean, you have a jury in a court case, so that has to do with the law. All right, de facto segregation, kind of the segregation in fact that's kind of practiced in the North as well as kind of all over the country to varying extents, but it's hard to fight against because, a law won't get it done. You got to convince folks that they need to live together, go to school together, and that's a harder sell. Okay, so we start with our court case, Plessy versus Ferguson. Homer Plessy was 1/8 African American. He was thrown off the white section of a train. It was in Louisiana. Louisiana had segregation laws, and it was strangely enough the train company that didn't like the law. So they set up this kind of test. Same way the NAACP set up Rosa Parks for a test on the bus system. So he gets thrown off the train. NAACP sues, and the Supreme Court ruled that the segregation system didn't violate the Equal Protection Clause of the 14th Amendment, that things could be separate as long as they were separate but equal. All right. 60 years later, 58 years later, 58 years later. This gets overturned by Brown versus Board of Education. There's a number of kids in a number of school districts, but Linda Brown's name comes first in the alphabet, B. And she lived close to a white school. She had to attend a black school, quite a ways away from where she lived. So her case went to the Supreme Court. And there's two parts. There's a Brown versus Board of Education in 1954, then one in 1955. All right, in part one, the court ruled that separate was never equal. And it's based on sociological studies where kids in black schools in the South, in elementary schools, were given two dolls, a white Barbie doll and a black Barbie doll, and that's which one's better, and they always pick the white one. So the conclusion the sociologists were reaching was that segregation was harming the identity, the self-esteem of the black kids in those schools. Okay, then the question was, well, how fast do schools have to be desegregated? And in 1955, the court ruled that should be desegregated with all deliberate speed, which meant different things to different people. If you were a proponent of integrating the schools, it meant fast, and if you're against it, it meant deliberately. A couple of famous folks out of this. Thurgood Marshall is the NAACP lawyer. Remember, it's the NAACP that goes to the courts. You go through the courts when you're not popular, when you don't have the votes to get bills passed in Congress. And Earl Warren was the Chief Justice of the Supreme Court. The Warren Court is the most liberal Supreme Court we've ever had. Okay, there they are. Look at them. Pause it as long as you want to. Answer the questions. No time like the present to get it learned. Okay, next. The Montgomery bus boycott. So kind of like Plessy versus Ferguson. Things kind of get set up. The NAACP sets up Rosa Parks to refuse to go to the back of the bus in Montgomery, Alabama. And Martin Luther King, who was 23 years old, was chosen to lead a 10-month boycott. And it may be longer than that. I'm going to say like 13 months, I think, of the Montgomery bus system. If you remember from class, the quote, nice civil rights quote coming out of there. The lady, the senior citizen, told Martin Luther King, my feet are tired, but my soul is rested, towards the end of that boycott. But the result was that only the Montgomery bus system integrated. Okay, 1957, 3 years after Brown versus Board of Education, or maybe 2 years after the instruction to desegregate the schools with all deliberate speed. Central High School in Little Rock, Arkansas, 9 African American students attempt to desegregate it. And Faubus, Orville Faubus, who had been a civil rights moderate, calls out the National Guard to stop him because he knows he's not going to get reelected if they get in that school. Eisenhower, on the other hand, who's kind of a civil rights conservative, kind of against it, is enforcing the law. So he calls out the Army to help the kids get in there. They did not, they got into the school, then the school got shut down. Everybody went to school together the next year. But Faubus, being a delegate in this situation, it worked out for him. He got reelected a bunch of times and declared most popular man in America by Reader's Digest several years in the late 50s. All right, the sit-ins are coming in 1960. Now been 6 years since Brown versus Board of Education. As college kids getting kind of impatient, so SNCC is the group doing it. John Lewis is in on that one. This one takes place by and large in North Carolina, although there were sit-ins kind of all over the South. There were sit-ins in Atlanta, but mainly North Carolina. So they'd ask for service. It'd be white and black college kids getting together, sitting at the lunch counter, ask for service. They'd be refused. People would pour stuff on them. Then they start beating them on them. Then they get arrested. A few of the lunch counters got integrated by and large. Most of them got shut down. And generally speaking, department stores that you go shopping in don't have lunch counters today. Okay, there they are. I'm going to pause a second. And here we go. All right, next, looks like every Roman numeral is going to be number 2. 2, 2, 2, 2, 2. All right, what do we got? The Freedom Rise. Young people, again, this time it's CORE, Congress of Racial Equality. And this time the law says the buses are already integrated. These are interstate buses. The government's got the power to regulate interstate commerce. So it can say that the bus is supposed to be integrated. And they rode it from the integrated north down to the south. And they got attacked in Anniston, Alabama. People firebombed the bus, tried to keep them on there. Lewis was on that bus as well. Once they got off, they got beat up. When the bus made it to Mississippi, they were arrested for violating segregation laws at the segregated bus stations. Nothing really comes of it, although Lewis said he felt like he realized that he wasn't afraid of going to jail as a result of this. All right, there he is. The spots there on him are blood. I'm hoping that from the interstate we'll see the big John Lewis mural tomorrow, and at the very least at the different museums we ought to see plenty of pictures of him. My poster on the wall came from the MLK Center. The other guy here is feeling where his teeth used to be. Both of them got beat up pretty good. All right, next is the Children's March, 1963. And King is picking out Birmingham, also known as Birmingham, because it's kind of the perfect test case. If you can beat segregation in Birmingham, you can beat it anywhere. He gets arrested, riots letter from Birmingham jail, but then when he comes out, he can't get adults to march with him. So it's another guy, James Bevel, kind of leads the Children's March. And remember what they're doing. They're trying to fill up the jail, shut down Birmingham, and then Birmingham will have to negotiate for an end to segregation laws in Birmingham. Kennedy's watching all the stuff on TV. Day 2 is when the violence on behalf of the authorities kind of start. And so he proposes the Civil Rights Act. He's not any good at legislation. He's too cautious, so he can't get it passed. All right, so the March on Washington is designed to persuade America to support Kennedy's law that he's proposed. The I Have a Dream speech is made at the end of that day. There he is on the steps of the Lincoln Memorial. That's the Washington Monument off in the distance, and the folks are lined up around the reflecting pool. All right, there's a review. All right, next. So Johnson uses a treatment to get the Civil Rights Act passed. It ends the de jure segregation. Nevermore will bathrooms and drinking fountains and so forth say white and colored on them. So there he is with the treatment. That's Richard Russell, the leader of the Southern filibuster, who, incidentally, I mean, I guess the treatment worked and maybe it didn't. Didn't work on Russell. He never supported the Civil Rights Act. He led the opposition to it. And if you look close at Russell there, you see that, he's kind of used to that. If you actually look at his face, look at him. Now, I don't think he's all that intimidated, but that's the Johnson treatment. More treatment. Okay, the Voting Rights Act is coming out of the March in 1965 in Selma, Alabama. There's Lewis there. And here's Lewis here. It's called Bloody Sunday. King was in Atlanta preaching at Ebenezer, where we're going tomorrow. And the authority was afraid he was going to drown. Hosea Williams is the guy crossing the bridge with him there. And it was on TV, and so this time it's Johnson that's watching on TV and proposes the Voting Rights Act. He uses the phrase, "We shall overcome," which that's the anthem of the Civil Rights Movement. And hearing him say that in a Southern authority accent calls King to be overcome with emotion when he's watching it on TV. The Voting Rights Act prohibits discrimination in election. No more literacy tests. No more white primaries. Grandfather clause. 24th Amendment is going to get rid of the poll tax. There we are. Okay, stuff going on today. Affirmative action. So it encourages So this is this is where things get controversial. There's a lot of consensus on the Civil Rights Act and the Voting Rights Act. Not so the rest of this stuff. So affirmative action is the idea that it's not enough to say, okay, you ought to let people in your college, you ought to let people in your school. Because there's all kinds of ways folks can decide not to admit people or hire people. So it's the government encouraging people, encouraging schools and employers to admit and hire minorities. It becomes very controversial. It's always controversial, especially unpopular when it's seen as requiring numbers. 12% African American, so 12% got to be higher. 52% women, 52% of the admitted class got to be female. All right, Bakke versus California, as the case comes out of it, we got about 3 cases. Bakke was somebody from NASA who wanted to go to Berkeley medical school. He didn't get in. They started researching who did get in, and they was able to show that the minorities who got in were not as qualified as he was in terms of test scores, grades, that sort of thing. And so he got admitted. The court ruled that in fact it was reverse discrimination. However, the court also ruled that race can be a factor in making these decisions. It's become less popular. But there's all kinds of things that go into a hiring decision or an admission decision, including who your parents were, daughter of an alum, or if you're an athlete, that sort of thing. But here you got the people protesting against it. It has, in fact, become less popular. All right, got a couple court cases. Gratz versus Bollinger. The undergrad point system, affirmative action that University of Michigan used was ruled to be unconstitutional. However, the law school system was seen as acceptable, where race could be a factor as long as it wasn't a quota. So Michigan, according to the court, was allowed to do what it did at the law school, but not the undergrad. All right, so I'll pause. Okay, and then Michigan just outlawed it with a referendum altogether. No affirmative action. California did the same thing. Washington did the same thing. Notice all 3 of these are basically Democrat states. Now, Michigan went red this time, working class. Washington, California, very blue states. All right, President Obama was asked about affirmative action sometime towards the beginning of his time in office. And his response was, well, Sasha and Malia probably don't need it. They've got the they've got the advantages. So discrimination is not really stopping them. University of Texas came up with a 10% plan, saying the top 10% of every graduating class would be automatically admitted to the University of Texas. And so that would account for disadvantages faced not only by minorities in urban school districts, but also by rural white kids out in the country somewhere. So it makes it more of a economic issue rather than a racial one. Okay, busing. Last time you see bus, so you got the Montgomery bus boycott. The Freedom Rise now is Remember the Titans. And schools were desegregated, but because they tended to be concentrated in nearly all black areas or all white neighborhoods, they still were not integrated. In other words, you might have 1 or 2%, of a minority group in a particular school. So districts started using busing kids in from a different school that they were zoned to go to. And it was very controversial. This is an anti-busing protest in Boston. And so then you've got 2 court cases, Swan versus Charlotte, where the Supreme Court upheld Charlotte's busing plan. Meredith versus Jefferson County kind of put a qualification, watered down Seattle's busing plan. And busing, like affirmative action, has become less and less popular. I kind of speculated in class. When they got rid of West Rome and East Rome, they kind of put Rome High outside of town so that everybody, in a sense, is moving out of their area that they would be zoned for, and nobody's being bussed into anybody else. And, there's kids riding buses, but they're not riding buses into another neighborhood in another zoning area. Okay, then you got militant civil rights. Malcolm X is most famous for that, famous for saying any means necessary to get racial justice. He was assassinated by other members of the Nation of Islam in 1965. Nelson Mandela is kind of the mean between Malcolm X and Martin Luther King. He's got a Martin Luther King way about him, and he becomes president of South Africa. But he went to prison for about 20 years for refusing to renounce violence because black South Africans were the vast majority in South Africa. So if it came down to a racial war, he felt like black South Africans had a good chance. Whereas Martin Luther King is being very practical. In addition to his kind of golden rule morality of nonviolence, turn the other cheek. If there's a racial war in Alabama, Mississippi, Georgia, what's it going to win? They've got the guns, they got the numbers. All right, finally, Black Panthers, late 60s, associated with the gun control debate, except in reverse. They were concerned about police brutality, so they were using weapons. Went into the California State House, and Governor Ronald Reagan signed a gun control measure into law in California out of concern for the Black Panthers and their weapons. Okay, there you go. And here we go. All right, we have Seneca Falls, women's movement. All right, so the first women's rights convention was in Seneca Falls, New York. It's kind of one of those utopian movements coming out of the age of Jackson. They called for kind of equality of property rights and equality of the right to get a divorce. Not really equal pay. That's the kind of thing you're going to see in the 70s feminist movement, and some of them called for suffrage. These goals were sacrificed in favor of the abolitionist movement. And so, the 19th Amendment doesn't come till 1920. And, the saddest part of this story is none of these ladies, all of them worked for the right to vote their whole lives. None of them saw it happen. I think Mott died in maybe 1870, 1880, but Stanton and Anthony, I think both died somewhere around 1912, about 8 years before the 19th Amendment. So both inspirational and sad story. All right. So suffrage spread from the West. If ladies could be successful out West, they got respect that they didn't necessarily get in the East. Also, Western states need 60,000 people. Oh, gosh. I don't know what to do. I got a phone call. Hold on just a second. I'm sorry. Hello? Hey. That's a good question. I think if you park, let's see. I think that's a really good question. Hmm. I could meet you somewhere. I could meet you at the church and pick you up and just take you over there. I'll tell you what, can I, let me give somebody a call and let me give them a call you back. Or I'll call you back in about 20 minutes. That'll be okay? Okay. Okay. All right, great. All right, thanks. Bye. Sorry, that was one of our chaperones. Couldn't really not take it. Okay, for tomorrow. So what were we saying? Okay, so they get in the West. Women don't get the right to vote in the Bible Belt till 1920. So the 19th Amendment is kind of for the Bible Belt here. It's the East Coast. Um, and Southern states were concerned that they didn't like the idea of the 19th Amendment because they're afraid that folks from Washington, D.C., enforce the 19th Amendment would also look into civil rights election practices. Okay, you got Betty Friedan wrote The Feminine Mystique, I think it was 1962, and it's a critique of the life of a homemaker, saying it's boring, it's not fulfilling. Kennedy signed the Equal Pay Act right around 1962, 1960, somewhere. He's president from 61 to 63, so one of those 3 years there. Equal Rights Amendment did not pass. It needed 38 states. It got 35. Here you have Gloria Steinem. I'm not sure if I talked about her in both classes, but she's a little, so the women's movement becomes a little more militant in the 70s, just like the civil rights movement. So, you have that kind of progression towards militants. Okay, Title IX is Exhibit A for the success of women's rights movement. Signed in 1972 by surprisingly liberal President Nixon. It's been used to equalize sports funding. That young lady can dunk a basketball. The women have won the World Cup. Young ladies are doing great in sports and education. We read the article about what the boys' crisis in one of the classes. I don't think we did it in Black Day class today. Okay, there it is. Okay, so then you have these categories. All right, so discrimination, the constitutional provisions that would protect you against discrimination is the Due Process Clause of the Fifth and 14th Amendment, and also the Equal Protection Clause of the 14th Amendment. Okay. Race is something that the government does, race, religion, national origin is something that the government does not want people to be making distinctions based on. So those are called suspect categories. It's got to be a really unique situation. It's a Hollywood movie and the person is playing Martin Luther King. Well, they probably need to be black. A white person couldn't apply for that job. Or a person's going to be playing a Southern racist. A black person's not going to. So you have unique situations. The FBI is going to infiltrate some particular group. So, there's a few very unique situations in which distinctions can be made, but very rarely. So the government uses what's called strict scrutiny. Any kind of distinction made based on race, religion, or national origin is almost always unconstitutional. Okay, if we work our way down classifications, gender is not quite as suspect, so they call it quasi-suspect. You still usually get in trouble if you say, sorry, I can't hire you because you're a woman. But there's a few more areas than race, religion, or national origin where distinctions are allowed to be made. Our example in class is that ladies don't have to register for the selective service. So the scrutiny is intermediate. It's allowed a little more often, but still not very often. Okay, then rational basis scrutiny. Distinctions can be made based on age, wealth, political opinion, or disability. What was it? My example wasn't quite as good Gold Day, but today we said, let's say that I'm assuming that I'm at least going to be at Calhoun for the 4 years that Walt's at Calhoun. And y'all are going to college for 4 years. Let's say one of y'all wants to become a teacher, and after doing, 10 years at the same place, I'm ready for a change of scenery. So we both apply to Southeast Whitfield. Okay. Why might they hire you over me, even though I've got a lot more experience? Number one, you're going to cost less coming out of school. I would get a higher salary than you. Number two, if they hire you, I would have 25 years in. I'd be more likely to quit after a few years, whereas you might work there for 20 years or something like that. Number three, in the interview, they might decide that I've lost a step, that some of my answers don't make sense and that I'm a little senile, and so they need to hire somebody like you that's still nice and sharp. So it is seen as much more rational and reasonable to make distinctions based on age as opposed to race, religion, national origin, or even gender. Okay, so notice now you're matching, and I guess I'll go over this one with you. So each one's going to have two things that goes with it: scrutiny and classification. All right, so race, strict scrutiny, and it's a suspect classification. Gender, intermediate scrutiny, and it's quasi-suspect. Then age is rational basis scrutiny, and it's assumed that it's kind of okay to make that distinction. Oh, what was I saying? I'm planning on applying to work at Turf Builder this summer. So somebody can look at my bald head and decide, that bald head probably means a bad back. That guy's not going to be able to work for last more than about 2 days, so we're going to hire the young guy. All right, that is a reasonable distinction to be made. Okay, citizenship. So this is getting real close. About 2 slides here. All right, so there's 2 ways to become a citizen. If both of your parents are citizens, you're automatically a citizen. That's called law of the blood. If you're born here, coming out of the 14th Amendment, response to the Dred Scott case, if you're born in the United States, you're automatically a citizen. All right, somebody asked about somebody on vacation. I'm not sure. Well, we can check on that one. All right, but if you're not born in the United States and one of your parents is a citizen, you got all these very complicated things, which would apply to President Obama if he were born in Africa to only his mom as a citizen, because his dad was from Kenya. The birth thing, if the birthers had been able to show that he wasn't born in Hawaii, well then his eligibility for president would have been called into question. On the other hand, John McCain was born on a military base so not in the United States, but two U.S. citizens. So he qualifies on both counts because military base counts as U.S. soil. All right, this is a process for becoming a citizen. Naturalization is this process. So somebody who's here with permission has to live here for 5 years, speak and read English, be able to demonstrate they speak and read English, pass a test. Is kind of a college prep government test, really. Take a loyalty oath, show they're not going to be a terrorist, and then get character references. Okay, last 2 slides. Here's just kind of the immigration debate. There's 11 million undocumented immigrants in the country. And the 2 sides of the debate are a path to citizenship or permanent residency, at least. That's kind of the position of the left. And we know the Trump position tends to be deportation. And federalism has become an issue. In the Obama years, certain red states considered Obama too liberal on immigration, so they started enacting get tough immigration laws. And now under Trump, you've got blue states that are pledging to protect immigrants. So you got federalism going each way depending on the position of the president. If we look at our 2 models of federalism, The dual federalism model would say only the national government is responsible for this stuff. States don't have any say so. And cooperative state federalism would say, well, states have a role to play in it. There it is, and there it is. All right, let's see what I can do.